Welcome to the morning call. The International Criminal Court has asked South Africa and Burundi to reconsider its positions on its withdrawal from the Rome Statute. Now, South Africa, the economic giant of the continent, announced they were to begin the process of exiting the International Criminal Court, a move that has also left the world's justice institution a little bit shaken. Now, the backlash, however, is not only from the two countries, as other countries like Kenya and Uganda have contemplated the idea. From its adoption to when it came into force in 2002, the ICC and its principal appeared tolerant and acting for the greater good of the entire world. However, to date, it has indicted and prosecuted so far 90% Africans.
En effet, Robert, et la liste des griefs n'a pas
The list of grievances indeed continues to grow over the years. Since 2002, all of the investigations that the ICC has opened relate to the African continent, which has egged some African leaders who decry a justice that some describe as neo-colonial. As major powers like Russia, China or the United States had never acceded to the Rome Statute. However, the real fracture occurred in 2009 when an international arrest warrant against Sudanese President Omar al-Bashir was issued. That worsened when Uhuru Kenyatta was charged. The African Union requested a deferral of the case against the two heads of state for the duration of their mandate. At the 26th summit of the AU last January, African leaders backed the Kenyan proposal to prepare a roadmap for withdrawal from the ICC, despite the reservations of Burkina Faso or the Ivory Coast.
États africains faisant partie de l'organisme malgré des réserves émises par le Burkina Faso ou encore la Côte d'Ivoire.
Well, to join us in the morning today, we went to Ghana, where we are joined by Justice Shrem Sai. It's a country that has not experienced any scandal with regard to human rights violation or anything like that. He is a law lecturer at Ghana Institute of Management and Public Administration. Very good morning to you, Justice Sai. South Africa and Burundi have started the process to exit the ICC. Lots of other African countries are thinking about the same, they're contemplating this. But what are the implications of the decision?
For some time now, I'm sure you are already aware that African countries have been questioning the partiality of the court. So out of 10 people who have been convicted, 9 are Africans. What it means is that if you understand the language of discrimination, you probably will also appreciate that then it means that there is more than just legal law working. So then the African countries have decided on a number of platforms that they would rather prefer an international criminal court for Africa, which is also governed by Africans, to deal with African issues. So what this means is that they have taken the first step, that is South Africa and Burundi, have taken the first step, which may and is very likely to bring on board other African countries, for example, Kenya, Sudan, who have always questioned, the impartiality of the court, to also follow suit. So then, what it also means is that it may not be long when the court would lose its juicy subjects, which are the African states. If they pull out, what it means is that the court loses its force, its relevance, and to a very large extent, its usefulness.
Now, as a man of the law, Justice Shrem, are these grievances valid by these African states? Look at the statistics. 9 out of the 10 cases are believed in the ICC are believed to be of an African nature.
Well, it is valid to the extent that the issue of discrimination comes in. That is my personal opinion. But as you can see, atrocities, war crimes, crimes against humanity, genocide, Africa does not have monopoly over those crimes. So we have seen allegation of war crimes in Iraq, allegation of war crimes in Syria, allegation of war crimes all over the world. So the question is, how come it is only African countries or African leaders or African persons who are before the court? if the court itself should some introspection and finds a way of resolving these issues, it will be a better arrangement for the court itself. But now it appears it is getting too late, and once South Africa and Burundi have taken the steps, then we can be assured other African countries may follow based on what the African countries themselves have been saying on the various platforms of the EU. Now, the fact that we have made a case for discrimination at the courts level does not also automatically mean that we agree that then African leaders should commit crimes without being punished.
What happens, finally, just what happens if African states leave the Rome Statute in numbers? What's going to be the next move, and who will be holding African states accountable for any of these human rights, from genocide to war crimes and all that?
You have also heard, probably, that the African Union is setting up, is amending the African Court of Justice and the African Court of Human and People's Rights to make provision for trial of international crimes that happen in Africa. So what it means is that there are steps in place and are far advanced to establish an African court which will have jurisdiction to try the very crimes that the ICC is trying. What it also means is that then at the end of the day, an African leader or a person who commits war crime will not be left unpunished. Now the question is confidence in the new court or confidence in the African system. One of the things that affects administration of justice is legitimacy. Even at the time that the ICC itself was being established, the literature shows that there were criticisms about the viability of the court. There were criticisms about the legitimacy of the court. There were criticisms about fairness, partiality of the court. But then the court did not prevent the court from doing its work and did not prevent it from doing it the best way that it could. But that doubt in itself cannot in any way suggest that a court should not be formed to satisfy the legitimacy criteria, which is required for administration of justice, more so for administration of international justice.
Well, that was Justice Shremsai. Thank you for joining us on this edition of The Morning Call. Margaret Kimberley, a human